4. Rules and principles governing the activities of life insurance agents and accident and sickness insurance agents. Ethics and abiding with the rules of professional practice are fundamental to licensed insurance agents. A common objective of insurance regulators is to provide regulatory services that protect the public interest and enhance public confidence in the sectors they regulate. High ethical standards are critical to maintaining the public's trust in the insurance industry and in the profession of insurance agent. Trust and ethical behavior are viewed by clients as important characteristics in their relationship with a life insurance agent. Demonstrating ethical behavior and providing practical advice help build a trusting agent-client relationship. Ethical conduct includes the following: black small square dealing with conflicts of interest, black small square client needs analysis, black small square selling ethically, black small square meeting fiduciary obligations, black small square complying with statutes, regulations and codes of conduct. Sanctions for non-compliance with the principles and rules that apply to licensed insurance agents can include important monetary penalties and the revocation of the agent's license. The following sections define important concepts which must be understood and applied by all insurance agents: black small square role of the organizations that protect clients, black small square main responsibilities of a life insurance agent, black small square licensing process and regulations. The examples provided in the sections below demonstrate factual situations which illustrate the concepts and allow future licensed agents to familiarize themselves with the high standards expressed as principles and rules which are expected when carrying out their business. 4.1 Role of the organizations that protect clients. This section identifies the primary regulatory authorities overseeing life insurance agents and other relevant client protection organizations. It also outlines the regulatory framework regarding the conduct of life insurance agents and of accident and sickness insurance agents in Canada, which now increasingly focuses on proactive rather than reactive supervision. 4.1.1 Provincial and territorial regulatory authorities. The federal, provincial and territorial governments legislate and enact regulations for insurance companies. However, federal supervision under the Insurance Companies Act, as well as by the Office of the Superintendent of Financial Institutions, OSFI, is primarily to determine the financial soundness of the federally incorporated life insurance companies, while the provinces and territories are responsible not only to determine the financial soundness of the provincially or territorially incorporated life insurance companies, as the case may be, but also for licensing insurance agents and regulating the licensing of insurers operating within their jurisdictions as well as the marketing of insurance products. 191. The provinces and territories are also responsible for regulating market conduct. According to the Canadian Council of Insurance Regulators, CCIR, market conduct encompasses any product or service relationship between the insurance industry, insurers, agents and individuals alike, and the public. It is influenced by many factors including laws, established best practices, codes of conduct, and client expectations. 192. One priority is risk-based regulation, which directs the regulator's efforts toward issues which could have negative impacts on clients. The CCIR affirms that a risk-based approach could be used to focus regulatory attention on insurers where indicators suggest there is a high risk of non-compliance with the legislation rather than giving every insurer equal weight and examining them all. 193. In other words, breaches of compliance systematically generate and increase supervision by regulators. Regulatory authorities have a mandate to ensure fair, responsible, and professional conduct by life insurance agents. They fulfill their mandate by setting expectations and requirements for regulating the conduct of life insurance agents toward clients, including black small square promoting transparency to clients, black small square taking enforcement actions against breaches of conduct, black small square equipping clients with financial knowledge and skills, understanding financial concepts and terminology, black small square giving clients access to independent complaint resolution avenues, such as the Ombud service for life and health insurance. 4.1.2 Provincial and territorial insurance regulators. There are 10 provincial and 3 territorial regulators responsible for the regulation of agents and agencies. 194. As mentioned previously, OSFI is not responsible for the licensing, regulating, and supervision of an insurance agent's practice. 4.1.2.1 British Columbia. In British Columbia, life insurance agents, accident and sickness insurance agents, and corporate agencies are licensed by the Insurance Council of British Columbia, 195, while the British Columbia Financial Services Authority, BCFSA, 196 issues business authorizations to insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Financial Institutions Act, 197, the rules of the Insurance Council of British Columbia, 198, and the Code of Conduct of the Insurance Council of British Columbia. Point 199, there is no specific chapter regarding agents in the Insurance Act. 200. However, the Financial Institutions Act contains certain relevant provisions relating to insurance agents. Point 201. 4.1.2.2 Alberta. In Alberta, life insurance agents, accident and sickness insurance agents, and corporate agencies are licensed by the Alberta Insurance Council, part of the Alberta Treasury Board and Finance. Financial Sector, Regulation and Policy, 202, while the Office of the Superintendent of Insurance of Alberta, 203, licenses the insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act, 204, and the Life Insurance Council Code of Conduct. 205. 4.1.2.3 Saskatchewan. In Saskatchewan, life insurance agents, accident and sickness insurance agents, and corporate agencies are licensed by the Life Insurance Council of Saskatchewan, 206, while the Financial and Consumer Affairs Authority of Saskatchewan, Insurance and Real Estate Division, 207, licenses the insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Saskatchewan Insurance Act, 208, the Life Insurance Council Guidance Notes, 209, and the Life Insurance Council Bylaws. Point 210. Please note that on January 1, 2020, the Saskatchewan Insurance Act was replaced by the Insurance Act. 211. You will find a Schedule 3 that you may use as a table of concordance between the relevant sections of the Saskatchewan Insurance Act and the Insurance Act. In Saskatchewan, in order to be allowed to distribute segregated funds, a life insurance agent must have completed a course recognized by the Life Insurance Council of Saskatchewan. If a life insurance agent is not allowed to sell segregated funds, a restriction will appear on his license. Point 212. 4.1.2. For Manitoba. In Manitoba, life insurance agents and accident and sickness insurance agents are licensed by the Insurance Council of Manitoba, 213, while the Manitoba Financial Services Agency, Financial Institutions Regulation Branch, FIRB, 214, licenses the insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act, 215, the Insurance Agents and Adjusters Regulation 389/87, the Life Insurance Agents and Accident and Sickness Insurance Agents Licensing Rules, and by the Life Insurance and Accident and Sickness Agents Code of Conduct. Point 216. 4.1.2.5 Ontario. In Ontario, life insurance agents, accident and sickness insurance agents, and corporate agencies are licensed by the Financial Services Regulatory Authority of Ontario, FSRA, in replacement of the Financial Services Commission of Ontario, FSCO, 217, which also regulates insurers. That replacement occurred on June 8, 2019. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act 218 and by the Agents Regulation, 219 the replacement of Life Insurance Contracts Regulation, 220. The Unfair or Deceptive Acts or Practices Regulation, 221 the Variable Insurance Contracts Regulation 222, the Administrative Penalties Regulation 223, and the Code of Ethics for Life Insurance. Agents in Ontario, which does not have legal effects, unlike the Code of Conducts in British Columbia, Alberta and Manitoba, Point 224. Other regulations have come into force on July 1, 2016.225. For .1.2.6 Quebec. In Quebec, life insurance agents, accident and sickness insurance agents, insurance brokers and independent agencies are licensed by the Autorité des marchés financiers, AMF, 226 which also regulates insurers. However, the discipline of life insurance agents and accident and sickness insurance agents is the responsibility of the Chambre de la Sécurité Financière, CSF, while the AMF is responsible for the supervision and discipline of corporate agencies, firms and independent partnerships. Point 227. Life insurance agents and accident and sickness insurance agents are governed by an act respecting the distribution of financial products and services, 228 by the regulation respecting firms, independent representatives and independent partnerships, 229 the Code of Ethics of the Chambre de la Sécurité Financière, 230 the regulation respecting the issuance and renewal of representatives certificates, 231 the regulation respecting the pursuit of activities as a representative, 232 the regulation of the Chambre de la Sécurité Financière respecting compulsory professional development, 233 the regulation respecting the registration of firms, representatives and independent partnerships, the regulation respecting information to be provided to consumers, 235, and the regulation respecting the keeping and preservation of books and registers, 236. For .1.2.7 New Brunswick. In New Brunswick, life insurance agents and accident and sickness insurance agents are licensed by the Financial and Consumer Services Commission, FCNB, 237 which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 238. For .1.2.8 Nova Scotia. In Nova Scotia, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Office of the Superintendent of Insurance, part of the Nova Scotia Department of Finance and Treasury Board, Office of the Financial Institutions Division, 239, which also licenses insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 240. For .1.2.9 Prince Edward Island. In Prince Edward Island, life insurance agents and accident and sickness insurance agents are licensed by the Prince Edward Island Superintendent of Insurance, part of Justice and Public Safety, Consumer, Corporate and Financial Services Division, 241 which also licenses insurance companies. There is no license for corporate agencies. Non-resident corporate agencies are required to register under the Extra-Provincial Corporations Registration Act. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. For .1.2.10 Newfoundland and Labrador. In Newfoundland and Labrador, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Superintendent of Insurance, part of Service NL, Financial Services Regulation Division, 243, which also licenses insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Adjusters, Agents and Brokers Act. 240 for the Insurance Companies Act 245, the Insurance Contracts Act 246, the Life Insurance Act 247, and the Accident and Sickness Insurance Act 248 are equally relevant. For .1.2.11 Yukon. In Yukon, life insurance agents and accident and sickness insurance agents are licensed by the Office of the Superintendent of Insurance, Department of Community Services, Professional Licenses and Regulatory Affairs Branch 249, which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 250. 4.1.2.12 Northwest Territories. In the Northwest Territories, life insurance agents and accident and sickness insurance agents are licensed by the Office of the Superintendent of Insurance, part of Finance, which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 251. 4.1.2.13 Nunavut. Since April 1, 2013, the Government of Nunavut administers its powers under the Insurance Act itself. This is done through the Office of the Superintendent of Insurance of Nunavut, part of Finance. Point 252. Prior to that date, the Nunavut Insurance Act was administered by the Office of the Superintendent of Insurance of the Northwest Territories. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 253. 4.1.3 Canadian Insurance Services Regulatory Organizations (CISRO). The Canadian Insurance Services Regulatory Organizations (CISRO) defines itself as an interjurisdictional group of regulating authorities who are dedicated to developing consistent standards of qualifications and practice for insurance intermediaries dealing in insurance of persons and property. Point 254. The principal responsibility of the members of CISRO is to administer the regulatory system applicable to insurance intermediaries under their authority. Although CISRO members cannot enact legislation, they are key advisors to their governments on regulatory issues related to insurance intermediaries. The CISRO website includes a link to disciplinary actions taken by insurance regulators. This provides transparency to both the industry and clients. Point 255. The regulatory authorities also work with other authorities and agencies through the Joint Forum of Financial Market Regulators and maintain constructive dialogue with client associations on issues confronting the life insurance buying public. In September 2018, CISRO, in collaboration with CCIR, has published a guidance entitled Conduct of Insurance Business and Fair Treatment of Customers, which applies to insurers as well as insurance intermediaries, individual agents, brokers and representatives. According to the guidance, fair treatment of customers encompasses concepts such as ethical behavior, acting in good faith, and the prohibition of abusive practices. Ensuring fair treatment of customers encompasses achieving outcomes such as Black Small Square developing, marketing and selling products in a way that puts customers' interests ahead of their own. Black Small Square providing customers with accurate, clear, not misleading and sufficient information before, during and after the point of sale, which will allow them to make informed decisions. Black Small Square minimizing the risk of sales which are not appropriate to the customer's needs. Black Small Square ensuring that any advice given is relevant. Black Small Square dealing with customer claims, complaints and disputes in a fair and timely manner. Black Small Square protecting the privacy of customer information. 4.1.4 Other authorities providing client protection. There are a number of other authorities that protect the client. Those most relevant to the activities of a life insurance agent are discussed below in the following order. Black Small Square Office of the Privacy Commissioner of Canada. Black Small Square Financial Transactions and Reports Analysis Centre of Canada, FinTrack. Black Small Square Assuries. Black Small Square Ombud Service for Life and Health Insurance, OLHI. Black Small Square Canadian Council of Insurance Regulators, CCIR. 4.1.4.1 Office of the Privacy Commissioner of Canada. The mandate and mission of the Office of the Privacy Commissioner of Canada is to administer enforcement of the Federal Personal Information Protection and Electronic Documents Act (PIPEDA), Canada's private sector privacy legislation, and to protect and promote the privacy rights of individuals. 256. Life insurance agents operating in British Columbia, Alberta, and Quebec are subject to their own province's Personal Information Protection Act. Agents should recognize that they have a responsibility to keep client information confidential and to secure that information. 257. Example: Nancy, a licensed life insurance agent in Manitoba, kept her client files in an unlocked cabinet in her office or on her computer, which had her password taped to the keyboard. Her office was broken into, her files rifled, and her computer stolen. Nancy did not comply with PIPEDA. She should have made sure the files were kept in a secure place. 4.1.4.2 Financial Transactions and Reports Analyses Centre of Canada, FINTRAC. The Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, Canada's financial intelligence unit, was created in 2000. It is an independent agency, reporting to the Minister of Finance, who is accountable to Parliament for the activities of the centre. It was established and operates within the ambit of the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, PCMLTFA, and its regulations. FINTRAC's mandate is to facilitate the detection, prevention and deterrence of money laundering and the financing of terrorist activities, while ensuring the protection of personal information under its control. It fulfills its mandate through the following activities: Black Small Square receiving financial transaction reports in accordance with the PCMLTFA and regulations and safeguarding personal information under its control. Black Small Square ensuring compliance of reporting entities with the PCMLTFA and regulations. Black Small Square producing financial intelligence relevant to investigations on money laundering, terrorist activity financing, and threats to the security of Canada. Black Small Square researching and analyzing data from a variety of information sources that shed light on trends and patterns in money laundering and terrorist financing. Black Small Square maintaining a registry of money services businesses in Canada, and Black Small Square enhancing public awareness and understanding of money laundering and terrorist activity financing. 258. The Proceeds of Crime, Money Laundering, and Terrorist Financing Act 259 has the following key objectives. Black Small Square to implement specific measures to detect and deter money laundering and the financing of terrorist activities. Black Small Square to facilitate the investigation and prosecution of money laundering offenses and terrorist activity financing offenses. Black Small Square to respond to the threat posed by organized crime, and Black Small Square to assist in fulfilling Canada's international commitments to participate in the fight against transnational crime. Obligations of the Insurance of Persons Representative. Certain individuals, including staff of financial institutions and insurance of persons representatives, are required to report suspicious financial transactions to FINTRAC. FINTRAC published guidance that applies to insurance of persons representatives. 260 This guidance reiterates the obligations imposed on insurance representatives by the Proceeds of Crime, Money Laundering, and Terrorist Financing Act and the regulations adopted thereunder. The following are the principal obligations. Black Small Square establishment and implementation of a compliance program, 261. Black Small Square record-keeping requirements, 262. Black Small Square reporting requirements, suspicious transactions, terrorist property, large cash transactions, large virtual currency transactions, 263. Black Small Square Know Your Client requirements, including client identification requirements. White Small Square verification of clients' and beneficiaries' identity, individuals, legal persons and other entities. White Small Square ongoing monitoring of the business relationship. White Small Square identification of beneficial owners. White Small Square third-party determination, and White Small Square determination of politically exposed persons and heads of international organizations. 264. An insurance of persons representative has specific obligations under the Act and its regulations in order to help combat money laundering and terrorist financing in Canada. The representative is required to verify the identity of any person or entity, hereinafter the client or the beneficiary, for whom an information record is kept regarding the sale of an immediate or deferred annuity, or a life insurance policy. Black small square for which the client may pay $10,000 or more over the duration of the annuity or policy. Black small square for which a beneficiary may receive $10,000 or more over the duration of the annuity or policy. FINTRAC defines beneficiary as the individual or entity that will benefit from a transaction, or to which the final remittance is made. 265. This very broad definition covers any annuity payment or surrender transaction, in addition to death benefit payments. The representative must therefore, on the one hand, verify the client's identity in connection with the sale, if the client may pay $10,000 or more over the duration of the annuity or policy. On the other hand, he must verify the identity of the beneficiary indicated in the information record before the first payment is made to the beneficiary, if that beneficiary may receive $10,000 or more over the duration of the annuity or policy. In all cases, the identity must be verified within 30 days of the creation of the information record, regardless of the means of payment. The representative must at all times record the required information in the client's file. 266. Moreover, an identity need not be verified again if black small square the identity of an individual has already been verified, or the existence of an entity has already been confirmed using a method permitted by the Act and its regulations. Permitted methods are discussed later. Black small square the required documents are kept on file, and black small square no doubt remains as to the information obtained. Specific exceptions apply to the identity verification obligation. For example, an insurance of persons representative is not required to verify the identity of a person or confirm the existence of an entity at the time of purchase of a registered individual or group annuity contract or RSP, RIF, LIRA, LIF, DPSP, RPP, TFSA, etc., exempt life insurance contract. 267 An accident and sickness insurance contract without a cash surrender value. However, in some circumstances, an identity verification may nevertheless be required by the insurer for exempt plans or products. Where applicable, an identity verification allows the insurer to confirm the client's age or comply with its obligations under the Foreign Account Tax Compliance Act (FATCA) 268 and the Common Reporting Standard 269, Parts 18 and 19 of the Federal Income Tax Act. 2 International initiatives aimed at countering tax evasion by citizens or residents of other countries with accounts in Canada, and vice versa. For non-exempt insurance and annuity contracts, the insurance of persons representative is required to verify the client's or beneficiary's identity using one of the methods permitted by the Act and its regulations. The representative must do so for each policyholder or owner, including any co-policyholders, and for each beneficiary. Under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, the representative is required to properly verify the client's identity. Methods to verify the identity of persons and entities. 270. FINTRAC describes 5 methods to verify the identity of a person or an entity. 271 The approach depends on the type of client or beneficiary, individual, corporation, or other entity, and the context in the client's or beneficiary's presence or absence. 272. 1. Government-issued photo identification method. White small square the identification document must show the individual's name and contain the individual's photo. White small square the document must be valid, current, and original. White small square the document must contain a unique identification number. White small square the name and photo on the document must match the name and appearance of the person being verified. Some examples include a Canadian passport, a permanent resident card, a secure certificate of Indian status, a driver's license, and provincial or territorial identification cards. In Quebec, an insurance representative cannot ask to see a person's health insurance card, but can accept it if that person presents it for identification purposes. In Ontario, Manitoba, Nova Scotia, or Prince Edward Island, such use is prohibited. A social insurance card may not be used to verify identity, and a social insurance number, SIN, may not be used in a report made to FINTRAC. 273 A SIN is used for tax purposes only, and is required to that end in some types of insurance of persons contracts. When verifying someone's identity based on a piece of photo identification, a representative must obtain and record the following information. Black small square the name on the photo identification. Black small square the type of photo identification used. Black small square the photo identification reference number, black small square the place the photo identification was issued, and black small square the expiry date of the photo identification. 2. Credit file method. A credit file is used as an identification method to verify the identity of a person who is not physically present. This method requires that consent first be obtained from the client or beneficiary before consulting the information contained in the credit file. A specific independent identification product is then used to search the databases of a Canadian credit bureau, for example, Equifax Canada or TransUnion Canada. It is important to note that Canadian credit bureaus offer independent identification products that can be used to consult a credit file for identity verification purposes without affecting a person's credit score. To use the credit file identification method, the search has to be performed at the same time as the identity verification. A credit file cannot be used if it was obtained at an earlier date or if a copy was provided by the person to whom the file applies. The search results must meet the following criteria. Black small square the client's or beneficiary's credit file must have at least 3 years of history and must contain valid and current information. Black small square the name, address and date of birth in the credit file must be the same as those provided by the client or beneficiary. Black small square the credit file must be Canadian, as foreign credit files are not accepted, and the information in the credit file must be derived from more than one source, i.e. from more than one Trattoline. The copy of the search results from Canadian Credit Bureau databases must be kept in the client file, the report produced by the Canadian Credit Bureau, and must contain the following. Black small square the source of the credit file, for example, the name and logo of the credit bureau. Black small square the name of the person whose identity is being verified. Black small square the credit file reference number, and black small square the date the credit file was consulted. Where a Canadian credit bureau cannot authenticate even just one item of information on the client or beneficiary, for example, if the first name, last name, date of birth or address does not match, or if the credit file is not Canadian, has less than 3 years of history, or is derived from a single source, a single Trattoline, the credit file method alone cannot be used. At this point, another method must be used to verify the client's or beneficiary's identity. 3. Dual process method. The dual process identification method is used to verify the identity of a person that is not physically present. It requires performing 2 actions, consulting 2 independent credit transactions, or referring to 2 reliable and distinct sources to verify a client's or beneficiary's identity. On the one hand, a specific independent identification product can be used to search the databases of a Canadian credit bureau, for example, Equifax Canada or TransUnion Canada, as the aggregator, to compile information from 2 independent credit transactions dating back at least 6 months. The client's or beneficiary's consent must have been obtained first. These 2 credit transactions must have been carried out by the client or beneficiary with 2 independent and distinct business sources, and must have 2 of the following 3 matches. Black small square the client's or beneficiary's name and address. Black small square the client's or beneficiary's name and date of birth and/or. Black small square the name and existence of a financial account in the client's or beneficiary's name with a financial institution. Where a Canadian credit bureau cannot make 2 of the 3 matches mentioned above using 2 independent credit transactions dating back at least 6 months, another solution must then be used to verify the client's or beneficiary's identity. Various combinations are possible. Below are 2 examples. Black small square an analysis of the search results from Canadian Credit Bureau databases yields a first match from among the ones mentioned above. For example, the Canadian Credit Bureau matched and confirmed the name and date of birth of the client or beneficiary, and the verification of a document from a reliable source yields a second match. For example, a statement issued by a Canadian federal government agency confirms the name and address of the client or beneficiary, or Black small square. An analysis of the search results reveals that the Canadian Credit Bureau was unable to obtain any of the 3 matches mentioned above, in which case the representative must refer to information from 2 reliable and distinct sources such as white small square, a statement issued by a Canadian federal government agency to confirm the person's name and address, first match, and white small square, a deposit account statement confirming the person's name and the fact that he holds a deposit account in a financial entity, second match. The information obtained must be valid and current and must be derived from different reliable sources. Point 270 for examples include statements, letters, certificates, forms and other admissible and reliable information sources. Point 275. In all cases, the information provided by the client, first and last name, address and date of birth, must be the same as those obtained from the Canadian Credit Bureau or derived from reliable and distinct sources. The following details must be recorded. Black small square, the name of the person whose identity is being verified. Black small square, the date the information was consulted. Black small square, the name of the 2 different sources used to verify the person's identity. Black small square, the type of information used, for example, a utility account statement, bank statement or marriage certificate. Black small square, the number associated with the information, for example, the account number or reference number, and black small square, the account number associated with each Trattoline for information aggregated by a Canadian Credit Bureau. 4. Affiliate or member method. The identity of a person or an entity can be verified by confirming that one of the following entities has previously performed such a verification. Black small square, an affiliate that is one of the following reporting entities: RES Bank, Foreign Bank, Cooperative Credit Society, Savings and Credit Union, Caisse Populaire, Life Company, Foreign Life Company, Trust Company, Loan Company, or a person or entity authorized under provincial legislation to engage in the business of dealing in securities, or any other financial instruments, or to provide portfolio management, or investment advising services, other than persons who act exclusively on behalf of such an authorized person or entity. Black small square, an affiliate carrying out outside of Canada activities similar to those listed above. Black small square, a financial entity subject to the Proceeds of Crime, Money Laundering, and Terrorist Financing Act and member of the Financial Services Cooperative or Credit Union Central of the Insurance of Persons representative carrying out the verification. The name, address and date of birth in the records of the affiliate or the member financial entity must match the information provided by the person whose identity is being verified. For a corporation or other entity, the records of the affiliate or member financial entity must state that an admissible document was used and retained to confirm its existence, and that its name, its address, and the names of its directors were verified and recorded. The affiliate or member financial entity must have previously verified. Black small square, the identity of the person using the government-issued photo identification method, credit file method, or dual process method described earlier, or black small square, the identity of the corporation or other entity using the confirmation of existence method. This method is discussed in detail later. If the affiliate or member financial entity verified the person's or entity's identity prior to June 1, 2021, it must have done so pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing regulations using the methods in place at the time of the verification. When an affiliate or a member financial entity has previously verified a person's identity, the following information must be recorded. Black small square, the name of the person or entity whose identity was verified. Black small square, the date the identity was verified. Black small square, the name of the affiliate or member financial entity that verified the person's or entity's identity. Black small square, the method used to verify the person's or entity's identity, and black small square, the information and/or documents recorded by the affiliate or member financial entity according to the method used, including the date the identity was verified by the affiliate or member financial entity. 5. Reliance method. A person's or entity's identity can be verified by relying on the measures already taken by black small square, another RE from among the following: bank, foreign bank, cooperative credit society, savings and credit union, Caisse Populaire, Life Company, foreign life company, trust company, loan company, or a person or entity authorized under provincial legislation to engage in the business of dealing in securities, or any other financial instruments, or to provide portfolio management, or investment advising services, other than persons who act exclusively on behalf of such an authorized person or entity, or an entity that is affiliated with the insurance of persons representative, or with another RE, and carries out activities outside of Canada that are similar to those listed above, i.e. an affiliated foreign entity. When another RE or an affiliated foreign entity has previously verified a person's or entity's identity, the information recorded and the documents required must be promptly obtained from the other RE or affiliated foreign entity. This information and documents must be valid and current and must match those provided by the person or entity whose identity is being verified. The other RE or affiliated foreign entity must have previously verified the identity of the person using the government-issued photo identification method, credit file method, or dual process method described earlier, or the identity of the corporation or other entity using the confirmation of existence method. This method is discussed in detail later. If the other RE or affiliated foreign entity verified the person's or entity's identity prior to June 1, 2021, it must have done so pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing regulations using the methods in place at the time of the verification. In addition, the other RE or affiliated foreign entity must have had a written agreement or arrangement that requires all of the information it had referred to in order to verify the person's identity to be provided as soon as feasible upon request. Using a mandatory to verify the identity of a person. The insurance of persons representative can use a mandatory acting on his behalf to verify the identity of a person. A written agreement must previously have been reached with the mandatory to this effect. The representative remains responsible for the identity verification under the Act and its regulations, even though this task is entrusted to the mandatory. Any mandatory who verifies a person's identity on behalf of a representative must use the government-issued photo identification method, credit file method, or dual process method described earlier. Satisfy the current requirements for each of these methods and record the required information. If the mandatory verified the person's identity prior to June 1, 2021, he must have done so pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing regulations using the methods in place at the time of the verification. The information obtained must meet the criteria for verifying the person's identity. Verifying the identity of a corporation or other entity. To verify the identity of a corporation, an insurance of persons representative must consult one of the following documents. A certificate of incorporation. A record that the corporation has to file annually under provincial securities legislation, or the most recent version of any other record that confirms the corporation's existence and contains its name and address and the names of its directors, such as a certificate of active corporate status, the corporation's annual report signed by an audit firm, or a letter or notice of assessment for the corporation from a municipal, provincial, territorial, or federal government. The record used must be authentic, valid, and current. The insurance of persons representative must obtain the corporation's name and address and the names of its directors. To do this, a search may be performed in a provincial database, such as that of the Registraire de Enterprise du Québec, or federal database, such as the Corporations Canada database. The insurance of persons representative can also obtain this type of information by subscribing to an online corporation search and registration service. 113 Ethics and Professional Practice Chapter 4 Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. To verify the identity of an entity other than a corporation, the insurance of persons representative may use a partnership agreement, articles of association, or the most recent version of any other similar record that confirms its existence and contains its name and address. To verify the identity of a trust, the insurance of persons representative may use the deed of trust or, in the case of a testamentary trust, the will. To verify the identity of a succession, the insurance of persons representative may use a copy of the death certificate and the last will and testament of the deceased person. The record used must be authentic, valid, and current. If the insurance of persons representative consults a paper or an electronic record, he must keep that record or a copy of it. If the insurance of persons representative consults the electronic version of a record from a database accessible to the public, he must keep a record that includes the corporation's or other entity's registration number, the type of record consulted, and the source of the electronic version of the record. 276. Signing authority resolution corporations. When the client or beneficiary is a corporation, the insurance of persons representative must obtain a signing authority resolution clearly designating the individuals duly authorized to act and sign on behalf of the corporation. This record derives from the corporation's official registers and must be signed by all board of directors members entitled to vote on this resolution. Examples of documents to be used as a resolution include the certificate of incumbency, meeting minutes, and the corporation's bylaws. A corporation is a legal entity separate from its shareholders. It may be incorporated under provincial or federal legislation and usually has a permanent existence until its dissolution. Its aim is to operate an enterprise for the purpose of generating profit that will be distributed, as applicable, among its shareholders. 276. The FinTrack website also describes two other methods to verify the identity of a corporation or other entity. https://www. Information on the ownership, control, and structure of entities. The insurance of persons representative must obtain information describing the ownership, control, and structure of entities. Black Small Square Corporation, the names of all its directors and the names and addresses of all its beneficial owners. Black Small Square Trust, the names and addresses of all trustees, known beneficiaries, and known settlers of the trust. Black Small Square Widely Held or Publicly Traded Trust, the names and addresses of all trustees, and the names and addresses of all beneficial owners. Black Small Square Succession, the names and addresses of all liquidators or individuals who have control over the succession. Black Small Square Other Entity, the names and addresses of the beneficial owners. The insurance of persons representative must also take reasonable measures to confirm the accuracy of the information obtained, and must keep the records in which the required information appears when that information is first obtained and in the course of conducting ongoing monitoring of business relationships. Verification of beneficial owners. 277. The insurance of persons representative must obtain the required information on beneficial owners pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing Regulations. Beneficial owners are the individuals who directly or indirectly own or control 25% or more of a corporation or an entity other than a corporation. In the case of a corporation, the beneficial owners are often its shareholders. In the case of a trust, they are the trustees, the known beneficiaries, and the settlers of the trust. In the case of a widely held or publicly traded trust, they are all of its trustees, as well as all persons who directly or indirectly hold or control 25% or more of its units. In the case of a succession, they are its liquidators. Beneficial owners cannot be other corporations, trusts, or other entities. They must be the individuals who are the owners or controllers of the entity. It is necessary to search through all the possible layers of information of the chain of control of the corporation or other entity in order to determine the beneficial owners. It is important to consider and review the names found in the corporate, government, or legal documents consulted in order to make certain that they match the names of the individuals who have actual ultimate control of the corporation or other entity. The insurance of persons representative must also take reasonable measures to confirm the accuracy of the beneficial ownership information when that information is first obtained and in the course of conducting ongoing monitoring. 278 of business relationships. 279. Third-party determination requirements. A third party is the person or entity that instructs another person, or entity to conduct an activity or financial transaction on their behalf. As such, the third party is the instructing party as to the handling of the money or the performance of the transaction or activity in particular, and is also understood to be the on behalf of party. The insurance of persons representative must take reasonable measures to determine whether a third party is involved when a transaction or activity is carried out. This verification is carried out in order to identify a person or an entity that takes part in criminal activities relating to money laundering and terrorist activity financing, and that has another person or entity carry out a financial transaction in its place. Reasonable measures for third-party determination include asking the client if they are acting at the instruction of another person or entity, or asking whether another person or entity will be instructing on the account. The reasonable measures the insurance of persons representative takes to make a third-party determination must be documented in his compliance programs, policies, and procedures. The insurance of persons representative must take reasonable measures to make a third-party determination when he is required to. Black small square report a large cash transaction or keep a large cash transaction record, 280. Black small square report a large virtual currency transaction or keep a large virtual currency, VC, transaction record, 281. Black small square keep an information record, 282. With regard to this last point, the reasonable measures for third-party determination must be taken when the information record is created. However, some circumstances may subsequently arise, requiring another third-party determination. This occurs, for example, when a mandate in anticipation of incapacity becomes enforceable, or when a new person or entity provides instructions regarding the annuity or life insurance policy. Black small square if the insurance of persons representative determines that a third party is involved, he must take reasonable measures to obtain the following information on the third party. Black small square if the third party is a person, their name, address, telephone number, not required if the third party determination is made for a large cash transaction or large VC transaction, date of birth and occupation, or in the case of a sole proprietor, the nature of their principal business. Black small square if the third party is a corporation or other entity, its name, address, telephone number, not required if the third party determination is made for a large cash transaction or large VC transaction, the nature of its principal business, its registration or incorporation number, and the jurisdiction of issue of that number. Black small square the relationship between the third party and the following person or entity as applicable. White small square the person who conducts the large cash transaction. White small square the person who conducts the large VC transaction. White small square the person or entity that the information record is kept on. Regarding this last point, the relationship between the person or entity and the third party can be, for example, that of an accountant, a broker, a customer, an employee, a friend, or a relative. A third-party determination should also be made when the person or entity making an annuity or life insurance policy payment is not the person or entity on whom the information record is kept. The purpose of this verification is to identify ploys aimed at concealing, or making it difficult to trace, the origin of sums derived from criminal activity. There is an exception to third-party determination whereby an insurance of persons representative does not need to make a third-party determination when he keeps an information record on a beneficiary in connection with the sale of a life insurance policy under which he is to remit an amount of $10,000 or more to the beneficiary over the duration of the policy, regardless of the means of payment. Politically exposed person, CAP, and head of international organization, HIO, determination. PEPs and HIOs are entrusted with a prominent position that typically comes with extensive access to considerable resources and the opportunity to influence decisions. The access, influence, and control that PEPs and HIOs have can make them vulnerable to corruption and the potential targets of criminals who could exploit their status and use them, knowingly or unknowingly, to carry out money laundering or terrorist activity financing offenses. The family members and close associates of PEPs and HIOs are potential targets as well because they can more easily avoid detection. References to PEPs include both foreign and domestic PEPs. A foreign PEP is a person 283 who holds or has held one of the following offices or positions in or on behalf of a foreign state: black small square head of state or head of government, black small square member of the Executive Council of Government or member of a legislature, black small square deputy minister or equivalent rank, black small square ambassador, or attaché or counselor of an ambassador, black small square military officer with a rank of general or above, black small square president of a state-owned company or a state-owned bank, black small square head of a government agency, black small square judge of a Supreme Court, Constitutional Court or other court of last resort, or black small square leader or president of a political party represented in a legislature. These persons are foreign PEPs regardless of citizenship, residence status or birthplace. Foreign PEP status is permanent. A domestic PEP is a person 284 who currently holds, or has held within the last 5 years, one of the following offices or positions in or on behalf of the Canadian federal government, a Canadian provincial or territorial government, or a Canadian municipal government, black small square governor general, lieutenant governor or head of government, black small square member of the Senate or House of Commons or member of a legislature, black small square deputy minister or equivalent rank, black small square ambassador, or attaché or counselor of an ambassador, black small square military officer with a rank of general or above, black small square president of a corporation that is wholly owned directly by Her Majesty in right of Canada, or a province, black small square head of a government agency, black small square judge of an appellate court in a province, the Federal Court of Appeal, or the Supreme Court of Canada. Black small square leader or president of a political party represented in a legislature or black small square mayor of a city, town, village and rural, county, or metropolitan municipality, regardless of population size. A person ceases to be a domestic PEP 5 years after leaving office. AHIO is a person 285 who currently holds, or has held within the last 5 years one of the following offices or positions: black small square head of an international organization established by the governments of states, or black small square head of an institution established by an international organization. When we refer to the head of an international organization, or the head of an institution established by an international organization, we are referring to the primary person who leads that organization, for example, a president or CEO. There is no requirement for an institution established by an international organization to operate internationally. It is possible for it to operate only domestically, or in one jurisdiction. A person ceases to be a HIO 5 years after leaving office. If a person is a PEP or a HIO, certain members of their family must also be considered PEPs or HIOs under the Act and its regulations. These family members are black small square their spouse or common law partner, black small square their biological or adoptive child or children, black small square their mothers or fathers, black small square the mothers or fathers of their spouse or common law partner, mother-in-law or father-in-law, and black small square a child, children, of their mother or father sibling. A close associate can be an individual who is closely connected to a PEP or HIO for personal or business reasons. Some examples of a close association for personal or business reasons include, but are not limited to, a person who is black small square business partners with, or who beneficially owns or controls, directly or indirectly, a business with a PEP or HIO, black small square in a romantic relationship with a PEP or HIO, black small square involved in financial transactions with a PEP or HIO, black small square a prominent member of the same political party or union as a PEP or HIO, black small square serving as a member of the same board as a PEP or HIO, black small square closely carrying out charitable works with a PEP or HIO, or black small square the owner of a joint insurance policy with a PEP or HIO. The insurance of persons representative must take reasonable measures to determine whether a person is a PEP, HIO or family member or close associate of a PEP or HIO with respect to the following transactions. Black small square receipt of a lump sum payment in the amount of $100,000 or more in funds, or an amount of V.Sc equivalent to $100,000 or more in respect of an immediate or deferred annuity or a life insurance policy, and black small square remittance of an amount of $100,000 or more in funds, or an amount of V.Sc equivalent to $100,000 or more to a beneficiary over the duration of an immediate or deferred annuity, or of a life insurance policy. Some exceptions are described on the FINTRAC website. Point 286. When the representative determines that a person is a foreign PEP, or a family member or close associate of a foreign PEP, he must consider there to be a high risk of a money laundering (ML) or terrorist activity financing (TF) offense being committed. Specific obligations apply to keeping records, establishing the source of the funds, or VC used for the transaction, establishing the source of the foreign PEP's personal wealth, and having the transaction reviewed by a member of senior management. When the representative determines that a person is a domestic PEP, or HIO, or a family member or close associate of a domestic PEP, or HIO, he must finish the risk assessment 287 to determine whether a high risk of an ML or TF offense being committed exists. If the risk level is considered high, specific obligations apply to keeping records, establishing the source of the funds, or VC used for the transaction, establishing the source of the domestic PEP's or HIO's personal wealth, and having the transaction reviewed by a member of senior management. A member of senior management is a person who has the authority to make management decisions about transactions or accounts, and is accountable for them. Awareness of the ML or TF risks to which the representative is exposed, and awareness and understanding of the representative's obligations related to PEPs, HIOs, and their family members and close associates. If the insurance of persons representative is a sole proprietor with no employees, agents, or other persons authorized to act on his behalf, he is considered to be the senior manager. The insurance of persons representative must keep a record of the office or position, and the name of the organization or institution of the PEP or HIO, the date of the determination, the source of the funds or VC used for a lump sum payment or received from the annuitant of an immediate or deferred annuity or the holder of a life insurance policy, if known, the source of the person's wealth, if known, the name of the member of senior management who reviewed the transaction, and the date of that review. The representative can also include a record describing the nature of the relationship between a family member or close associate and the PEP or HIO, as applicable. Obligation to report suspicious transactions to FINTRAC 288. A suspicious transaction is a transaction or attempted transaction giving reasonable grounds to suspect that it is related to a ML or TF offense, whether or not it has been completed. In general, a transaction could be related to a ML or TF offense if it, or a series of transactions, raises questions or causes doubt, concern, or mistrust. There is no threshold or minimum amount for reporting a suspicious transaction. In addition to identifying suspicious transactions, the insurance of persons representative must also acknowledge the presence of ML or TF indicators. ML or TF indicators are potential warning signs likely to trigger suspicions or indicate that something is unusual in the absence of a reasonable explanation. These signs generally stem from one or more facts, behaviors, models, or other contextual aspects that reveal irregularities in transactions. A single indicator, in and of itself, might not be or appear suspicious, whereas in a given context, one or more indicators could arouse suspicion or cause unease. Below are a few examples. The client refuses to produce the required personal identification documents, wants to establish his identity through means other than his personal identification document, or inordinately delays in presenting his corporate documents. The client is accompanied and watched, secretive, nervous, or overjustifies himself. The client displays uncommon curiosity about internal controls, or unusual knowledge about legislation regarding suspicious transaction. Reporting. The client deposits large third-party checks. The client shows more interest in the cancellation than in the long-term benefits of the product. The transaction is unnecessarily complex for its stated purpose. The transaction seems to be inconsistent with the client's apparent financial situation or usual pattern of activities, or the client gives a post office box address rather than the street address of a residence. 289. The representative must have the means to detect, analyze, document and report suspicious transactions and attempted transactions. This includes black small square documenting the completed analysis and its result, including the evaluation of the facts and context surrounding the suspicious transaction, as well as the explanation of the link between this evaluation and the ML and TF indicators observed and the grounds for suspicion noted. Black small square taking reasonable measures to verify the client's or beneficiary's identity, if not already done. Black small square submitting the suspicious transaction report to FINTRAC, as soon as practicable, after having taken the measures described above to establish that reasonable grounds exist to suspect that the transaction, or attempted transaction is linked to the commission of an ML or TF offense. The report must include white small square a description of the facts, the context, the ML and TF indicators observed, and the grounds for suspicion noted as well as, where applicable, the suspected criminal offense related to ML or TF. White small square the reason the transaction, or attempted transaction is linked to an ML or TF offense. White small square details of the completed analysis and its finding, in particular supporting the link between the ML and TF indicators observed, the grounds for suspicion noted, and the finding of the analysis. Suspicious transaction reports are confidential. In addition, the insurance of person's representative must not disclose to the client or beneficiary that an analysis has been completed regarding a suspicious transaction, or that a report has been made to FINTRAC. Failure to fulfill the obligation to report suspicious transactions may lead to financial administrative penalties and serious criminal sanctions. The representative is protected from legal proceedings when submitting a suspicious transaction report to FINTRAC in good faith. Obligation to report terrorist property to FINTRAC 290. In Canada, Section 83.01 of the Criminal Code defines terrorist activity as an act committed, in whole or in part for a political, religious or ideological purpose, objective or cause, with the intention of intimidating the public with regard to its security, including its economic security, or compelling a person, a government or a domestic or an international organization to do or to refrain from doing any act. Property is defined as anything owned or controlled by a person or entity, whether tangible or intangible. This includes black small square real and personal property, as well as deeds and instruments that give a title or right to property or to receive money or goods, and black small square any property that has been converted or exchanged, or acquired from any conversion or exchange. Examples of property include cash, monetary instruments, for example, checks, bank accounts, prepaid payment products, securities, jewelry, precious metals or precious stones, real estate and insurance policies. Pursuant to subsection 83.011 of the Criminal Code, a terrorist group is defined as black small square an entity that has as one of its purposes or activities facilitating or carrying out any terrorist activity. Black small square a listed entity, 291 or black small square an association or group of such entities. The insurance of persons representative must fulfill the obligations under the Criminal Code and the regulations implementing the United Nations resolutions on the suppression of terrorism for reporting terrorist property to FINTRAC. On the one hand, the representative must have implemented documented measures and processes to check the list of his clients and identify any clients who appear on the official lists disseminated by Canadian oversight bodies. On the other hand, when the representative knows that property in his possession or available to him belongs to a terrorist or terrorist group, or is available to them, he must report it to FINTRAC as soon as possible. He must also submit a report to the Royal Canadian Mounted Police, RCMP, and the Canadian Security Intelligence Service, CIWM. At the same time, if FINTRAC determines that there are reasonable grounds to suspect that the information represents a threat to Canada's security, he can also forward the information to CIWM. Terrorist property reports differ from other reports submitted to FINTRAC because a transaction, or attempted transaction, need not have been completed for the representative to submit a report. It is the mere existence of property, such as a bank account, owned or controlled by or on behalf of a terrorist group or listed person, that prompts the obligation to submit a report to FINTRAC. Terrorist property reports are confidential. In addition, the insurance of persons representative must not disclose to the client or beneficiary that an analysis has been completed regarding such property or that a report has been made to FINTRAC. Failure to fulfill the obligation to report terrorist property may lead to financial administrative penalties and serious criminal sanctions. The representative is protected from legal proceedings when submitting a terrorist property report to FINTRAC in good faith. It is important to note that the obligation to submit a terrorist property report does not exclude the obligation to submit a suspicious transaction report to FINTRAC if a transaction was completed or attempted and the representative has reasonable grounds to suspect that it is linked to the commission or attempted commission of an ML or TF offense. 292. Obligation to report large cash transactions to FINTRAC. 293. It should be noted that insurers rarely accept cash payments. However, the insurance of persons representative must submit a large cash transaction report to FINTRAC if he receives an amount of $10,000 or more in cash in the course of a single transaction, or two or more amounts that total $10,000 or more within a consecutive 24-hour window made by or on behalf of the same individual or entity. He must submit the large cash transaction report to FINTRAC within 15 calendar days after the transaction. He does not have to make a large cash transaction report to FINTRAC if the cash is received from a financial entity, bank, credit union, Caisse Populaire, etc., or a public body or its agent, government department or ministry, hospital authority, etc. Obligation to report large virtual currency, VC, transactions to FINTRAC. 295. It is important to note that insurers rarely accept payments or transactions in VC. However, the insurance of persons representative must submit a large VC transaction report to FINTRAC if he receives an amount in VC equivalent to $10,000 or more in a single transaction, or two or more amounts in VC that total $10,000 or more within a consecutive 24-hour window, and the transactions were conducted by the same person or entity, or were conducted on behalf of the same person or entity, or are for the same beneficiary. The representative must submit a large VC transaction report to FINTRAC within 5 working days after the day he receives the amount. For more information on this topic, see the FINTRAC Guideline on Reporting Large VC Transactions. 296. 4.1.4.3 Assuries. Assuries is a not-for-profit organization that protects Canadian policyholders if their life insurance company should fail. 297 Life insurance agents must understand what would happen if an insurance company became insolvent. The insured is automatically covered under Assuries because all federally regulated insurers and most provincially regulated companies must be part of Assuries. If a company were to fail, the insurer's primary regulator would appoint a liquidator. It would first attempt to transfer the policies to other insurance companies. If the liquidator had to reduce benefits, Assuries protection would apply. The levels of protection, summarized here in Table 4.1, should address any client concerns. Table 4.1, Assuries Protection. 298. Benefits Assuries Protection. Additional information. Death accumulated value 100% up to $100,000. No additional coverage. 4.1.4. Ombud Service for Life and Health Insurance, OLHI. The Ombud Service for Life and Health Insurance, OLHI, is a national independent complaint resolution organization providing clients with assistance to their inquiries and complaints pertaining to Canadian life and health insurance products and services. In certain circumstances, OLHI may direct life insurance agent-related complaints to the appropriate insurers. 299. 4.1.4.5 Canadian Council of Insurance Regulators, CCIR. Similarly to CISRO, the Canadian Council of Insurance Regulators, CCIR, is an interjurisdictional association of insurance regulators. The mandate is to facilitate and promote an efficient and effective insurance regulatory system in Canada to serve the public interest. 300. Under the supervision of the CCIR, Canadian insurance regulators have adopted a framework aimed at prioritizing the most important issues, based on their potential impact, risk, to the achievement of desired regulatory outcomes. 301. In managing key risks to clients, the regulatory authorities' priorities are being directed at Black small square strengthening the foundation of market conduct. Black small square implementing an enhanced market conduct supervisory framework. Black small square making the supervision of insurance intermediaries more effective. Black small square assisting clients through targeted financial education programs, such as fraud alerts and client information portals. As indicated by the Canadian Council of Insurance Regulators, CCIR, the framework includes both micro-level outcomes that are within the control of individual firms or intermediaries and broader systemic-level outcomes that can only be achieved through the collective actions of the entire industry. 302. In other words, companies or intermediaries may have an impact in their regions or on their respective customers, but a larger impact can be generated by the adoption of measures or regulations that apply to the entire industry. 4.1.5 Professional associations. There are also a number of organizations that encourage the professionalism of life insurance agents. These include the Canadian Life and Health Insurance Association, CLHIA, 303 Advocis, 304 the Independent Financial Brokers of Canada, IFB, 305 FP Canada, 306 and the Financial Planners Standards Council, FPSC. 307 These promote the obtaining of professional qualifications, continuous professional development, ethical behavior within the industry, and fair treatment of clients. 4.1.6 International Association of Insurance Supervisors, IAIS. The International Association of Insurance Supervisors, IAIS, 308 representing insurance regulators of more than 200 jurisdictions in nearly 140 countries, has adopted 26 Insurance Core Principles, ICP, with a view to promoting effective and providing globally consistent supervision of the insurance industry and contributing to global financial stability. It is a strategic initiative of CISRO and the Canadian Council of Insurance Regulators, CCIR, to ensure that the Canadian regulatory system meets all internationally agreed upon standards as well as to keep informed on emerging issues that may be identified outside Canada. 4.1.6.1 Insurance Core Principles, ICP, 18 and 19 of the IAIS. Insurance Core Principle, ICP, 18, entitled Intermediaries, covers the supervision of life insurance agents, and ICP 19, entitled Conduct of Business, the activities and behavior of life insurance agents. The rules emphasized in these ICPs are for the most part reflected in the existing codes of conduct of most of the regulatory authorities and insurance companies with the view to protecting clients and supporting their best interests. 4.2 Main responsibilities of life insurance agents. This section identifies the main responsibilities of life insurance agents and how they are required to work within a business conduct framework that adheres to the Provincial Insurance Acts and the codes of conduct required by regulators, insurers, and industry associations. Ethics and professional practices should always be at the core of the activities of the insurance agent. Obtaining an insurance license is a privilege which requires that all agents respect and apply the principles and rules which are imposed by applicable legislation, codes of conduct, and contractual documents. It is fundamental for agents to always be aware that ethics and sound professional practices are not only an obligation, but that any form of non-compliance can lead to stiff penalties, 309, which include applicable monetary penalties and even the revocation of an agent's license. The Insurance Council of British Columbia Code has the following introduction. The strength of the insurance industry is based, in part, on industry members providing advice and services to the public in a competent and professional manner. The underlying principle of all insurance business is utmost good faith. To command the confidence and respect of the public, the insurance industry must maintain a reputation for integrity, competence, and good faith. 310. This introduction is a reflection of principles and rules set out in all the other codes of conduct across Canada. Principles generally motivate or encourage certain behavior such as the obligation to act in good faith. Rules prohibit or sanction behavior such as the prohibition against forgery. Table for point 2 sets out the differences between principles and rules under the Ontario Insurance Act Regulations 311. Table for point 2. Differences between principles and rules. Differences between principles and rules. Principles required of an agent, rules imposed upon an agent. An applicant for a license shall be granted a license if the superintendent is satisfied that the applicant is of good character and reputation. An agent who holds a life insurance license shall not offer inducements, or use coercion or undue influence in order to control, direct, or secure insurance. An applicant for a license shall be granted a license if the superintendent is satisfied that the applicant is not engaged in any business or occupation that would jeopardize the applicant's integrity, independence, or competence as an agent. An agent who holds a life insurance license shall not make a false or misleading statement or representation in the solicitation or registration of insurance. An applicant for a license shall be granted a license if the superintendent is satisfied that the applicant intends to hold himself, herself, or itself out publicly and carry on business in good faith as an agent. An agent who holds a life insurance license shall not coerce or propose, directly or indirectly, to coerce a prospective buyer of life insurance through the influence of a professional or a business relationship, or otherwise to give a preference with respect to the policy of life insurance that would not otherwise be given on the effecting of a life insurance contract. An agent's conduct, practices, and decisions can be guided by the following principles and rules. Black small square acting in good faith. Black small square managing conflicts of interest properly. Black small square refraining from unfair or deceptive practices. Black small square making full disclosure. Black small square acting in compliance of regulation. Black small square handling complaints in a timely and fair manner. 311. Agents, O. For point 2.1 acting in good faith. Acting in good faith or in a manner that is consistent with the client's best interests is a fundamental aspect of an agent's business conduct, as well as a key element in the guiding principles of applicable codes of conduct and ethics, whether mandatory or voluntary. The components of acting in good faith are: black small square duty of care, black small square integrity, black small square competence. For .2.1.1 duty of care. It is the responsibility and obligation of life insurance agents to avoid careless acts or omissions. The Code of Conduct from the Life Insurance Council of Alberta states under duty of care that the client's interests take priority over the interests of the agent. 312. Example. After meeting with a client and completing the life application, Erica, a life insurance agent, was in a rush to leave on a long weekend trip. She locked the application and initial premium in her desk drawer. However, she forgot to submit the application after the long weekend. It was not until a few weeks later, when the client inquired about the status of the application, that she remembered it was still inside the drawer. Erica's action did not meet the standard of care expected of an agent, as she did not put her client's interests first. For .2.1.2 integrity. It is essential that life insurance agents act with integrity. These relate to qualities such as black small square being honest, trustworthy, and fair. Black small square being reliable, dependable, and respectful. The Insurance Council of Manitoba's Code of Conduct confirms that if personal integrity is missing, there is little an agent can do to compensate for its absence or to repair the damage to his reputation. 313. Felicity, an insurance agent, helped a client apply for a multi-million-dollar permanent policy and collected the $100,000 annual premium with the application. Felicity believed that the permanent policy was not suitable for the client's needs, without discussing it with her client, but proceeded with the application at the client's request, as she was only interested in the commission she would receive from the insurer. Through her behavior, Felicity demonstrated a lack of integrity. For .2.1.3 competence. The codes of conduct stipulate that life insurance agents should only carry out business in respect to the products and services for which they have the required competence. If an agent encounters a situation where his knowledge and skills may not be sufficient to make a well-founded recommendation, then the agent has an ethical duty to either ask for technical assistance from a colleague or refer the client to someone who can provide the assistance. As the Insurance Council of British Columbia affirms, incompetent conduct can result in significant prejudice to clients and insurers. 314. Example: Sandra, a life insurance agent, does not have experience in annuity products. She tells L.L., a prospective client, that she could prepare a customized proposal for a back-to-back insured annuity. This strategy, she says, will increase the client's guaranteed stream of income at retirement while minimizing the tax payable. Sandra has committed to provide information on a complex transaction without understanding what is involved. Sandra should have simply told L.L. that she would obtain the technical assistance needed from colleagues in her agency. Together, they could have prepared a proposal that would have met the needs expressed by the client. The combination of care, integrity, and competence, often referred to as acting in good faith, will not only help build the life agent's reputation, but it will also achieve the marketplace outcome, clearly stated by the regulatory authorities, that clients be treated fairly. 314. Insurance Council. 4.2.2 Managing Conflicts of Interest. A conflict of interest is a situation in which a life insurance agent is motivated to take action by an interest other than that of the client. Placing the interests of a client second to the agent's interest is contrary to the expectation of all regulatory authorities that clients be treated fairly. Before clients agree on an insurance contract or receive advice from a life insurance agent, any potential conflicts of interest, whether such conflict is real or apprehended, must be disclosed and managed appropriately. The CCIR and CISRO require that agents address the following principles. 315. Black small square priority of client's interest. Black small square disclosure of conflicts or potential conflicts of interest. Black small square product suitability. To comply with these three principles, regulatory authorities have set them out in their respective codes of conducts, as illustrated below. 4.2.2.1 Priority of client's interest. The interests of the client must be placed ahead of those of the life insurance agent. According to the Insurance Council of Manitoba's Code of Conduct, a life insurance agent must black small square not knowingly prejudice the interests of a client for personal gain. Black small square not take advantage of a client's or an insured's inexperience or ill health. 316. Example: Martha, a group insurance agent, is married to Roberto, VP of group insurance sales at a prominent life insurance company. Though she acts as agent for several life insurance companies, she often feels compelled to recommend Roberto's employer, as she knows that sales for Roberto's company may affect Roberto's performance bonus. In such a situation, Martha is in a conflict of interest. 4.2.2.2 Disclosure of conflicts or potential conflicts of interest. The Insurance Council of Manitoba's Code of Conduct states that an agent must openly disclose any conflict of interest, and that agents must not place themselves in one, unless the client approves of the intended conduct. 317. Example: Patrick is a life insurance agent and is also the majority owner of Cuppies, the most successful cupcake shop in town. Sal intends to open a similar shop across the street from Cuppies, and wants to obtain insurance on the life of his pastry chef. To do so, he contacts Patrick, whom he only knows as an insurance agent. At their first meeting, Patrick must disclose his majority stake in Cuppies. 4.2.2.3 Product suitability. Agents are expected to follow appropriate client needs-based sales practices to make the most suitable recommendations for prospective client. The recommended product must be suitable to the needs of the client. The client's insurance needs analysis must also show that the agent has understood the client's needs, and that he puts the client's interests first. According to the Alberta Code of Conduct, a life insurance agent must black small square perform a client needs analysis, gathering all the necessary facts required to assess them. Black small square recommend the products that meet the client's needs. Black small square explain and document the products recommended. Point 318. Best practices for determining product suitability during a typical individual life insurance sales process with a client have been developed collaboratively by industry associations. Point 319. They are listed below in sequence. Black small square disclosure to client. Black small square client expectations. Black small square fact finding. Black small square needs assessment. Black small square recommendations and advice. Black small square product information. 4.2.2. For avoiding conflict of interest occupations. Generally, it is a licensing requirement that the agent not be engaged in any business or occupation that would jeopardize the applicant's integrity, independence, or competence. Regulatory authorities can restrict certain types of additional employment for life insurance agents. For example, restrictions exist on the licensing of clergymen, liquor store employees, or police officers. Historically, provincial legislation had provided for a list of restricted occupations with regards to selling life insurance. However, regulators have moved away from this approach to provide for a broader restriction, which is as follows: the individual must not be in a position to use coercion or undue influence in order to control, direct, or secure insurance business. 320. Example: Justin works part-time as an independent insurance agent. He is also enrolled as a student to complete the education and training courses required to become a police officer. Following completion of his police officer training, Justin is surprised to learn that employment as a police officer may be incompatible with the activities of an insurance agent. After checking with his provincial regulator, he is told that he may not simultaneously act as an insurance agent and be employed as a police officer, as the latter carries the possibility of exercising undue influence or even coercion when securing insurance business. 4.2.3 Refraining from unfair or deceptive practices. Provincial and territorial regulatory authorities define and prohibit certain practices that are unfair, misleading, or deceptive. Below are some of the most common prohibited practices that can occur, which are set out for the most part in codes of conduct, as well as in insurance acts and industry guidelines. 4.2.3.1 Tide selling. Tide selling involves making a purchase of one product conditional on the purchase of another. This practice is prohibited as the transaction provides more benefit to the agent than to the client. 321. According to the Life Insurance and Accident and Sickness Insurance Agents Code of Conduct of Manitoba, it is an unfair or deceptive act or practice for an agent or broker to assist in or engage in the practice of tide selling. Anik, a life insurance agent representing a single insurer, tells Gary, her client, that he qualifies for a registered retirement savings plan, RRSP, loan. However, Anik tells Gary the loan is conditional on Gary transferring his current RRSPs into products offered by the life insurance company that Anik represents. This is not true and therefore deceptive, but Gary trusts Anik and does as she suggests. Anik should never have made one transaction conditional on the purchase of another product or service. This is unethical behavior, as she is the only person to benefit from the transaction. 4.2.3.2 Churning and twisting. Churning occurs when an agent encourages a client to give up one product for another, usually from the same insurer, in order for the agent to benefit from the commission. 323 This is a prohibited practice, and according to CLHIA guidelines, an unacceptable sales practice. 324. Example: Christine replaced an agent who had retired. In order to take advantage of her new clients for her own benefit, she advised one of them that he should buy a term annuity with his existing registered retirement savings plan, RRSP, to provide income, and reinvest the portion he did not need in an individual variable insurance contract, IVIC. Christine earned a commission on both the purchase of the annuity and the investment in the IVIC. A relative of the client discovered what had happened and complained to the insurer, who terminated Christine's contract. The client subsequently sued Christine and the insurer. Twisting is when an agent persuades a client to terminate a policy in view of replacing it with another one, generally from a different insurer. Point 325. The sale does not always benefit the client. Often, important information on the full consequences, financial loss of terminating their policy is withheld by the agent. The agent profits from the commission that the new sale generates. According to the Independent Financial Brokers of Canada's IFBC Code of Ethics, an agent must not recommend the replacement of any insurance policy unless she believes that such a replacement is in the best interest of the client. 326. Example 1. Alexei's life insurance agent recommends that he replace his policy with a new one with a larger death benefit from another insurance company. He omitted to explain to Alexei that there are tax consequences in canceling the current policy, which has a substantial cash value, assuming a new one will be issued. Furthermore, he neglects to inform Alexei about the new 2-year incontestability clause and the new 2-year suicide clause. Example 2. Shabir had a 3-year deferred annuity contract with one insurance company. An agent, licensed by a competing insurance company, told Shabir to surrender that annuity and purchase one his company offered, which currently offered better rates and more stability. Shabir was not told that the products were different, that there are exit fees, or that the replacement product had higher investment risk. For .2.3.3 Premium rebating. Premium rebating involves an agent giving back or rebating a portion of the premiums. The Insurance Act of Ontario describes premium rebating as an unfair or deceptive act or practice when a person pays, allows or gives, directly or indirectly, a rebate of all or part of the premium stipulated by a policy to a person insured or applying for insurance. Point 327. Irving met with his client's son Stephen to sell him a life insurance policy. Since Stephen was reluctant to sign, Irving offered to pay the first premium. In effect, Irving was offering a rebate. Irving should not offer to pay the first premium as an incentive for clients to purchase. For .2.3. For trafficking in insurance. Trafficking in insurance occurs when an agent acts as an intermediary between a policyholder who wishes to sell a policy, give up or absolute assignment, and a potential buyer. Point 328. A policyholder might sell his policy to a third party because the beneficiaries have died or he has enough wealth to self-insure, without paying further premiums. The insurance policies are usually universal life (UL) or whole life but may also include term insurance. Trafficking in insurance is prohibited in some jurisdictions, such as Newfoundland and Labrador. Point 329, as set out in the Insurance Companies Act of Newfoundland and Labrador. A person other than an insurer, or its authorized agent who advertises or holds himself or herself out as a purchaser of life insurance policies, or of benefits under life insurance policies, or who traffic or trades life insurance policies for the purpose of procuring the sale, surrender, transfer, assignment, pledge or hypothecation of them to himself or herself or another person, is guilty of an offense. Point 330. However, even in the jurisdiction where it is not prohibited, such conduct is discouraged by the industry. Several insurers have a policy against that practice and might terminate the relationship with a life insurance agent participating in it. Example: Jamie, an insurance agent who is also registered as a mutual fund salesperson, arranged the sale of viatical settlements 331 insurance policies assigned by terminally ill individuals to a corporation to his clients. He is required to place all business through his employer, which he did not do, and made profit on the sales. This is an unethical and even illegal practice in some jurisdictions. For .2.3.5 Inducing to insure. An agent cannot use a gift or offer of payment to convince a client to purchase insurance. This is known as inducing an individual to insure, and is a prohibited practice as set out in a number of regulatory documents, such as the Prince Edward Island Insurance Act S. 376.332. Example 1. Lorraine is negotiating with a company's vice president to set up a group insurance plan. She learns that another agent has approached the person. She buys the vice president a case of very expensive wine in the hope that he will agree to do business with her. Lorraine should not try to encourage the vice president to do business with her because of the gift she has offered. Example 2. Nadia offers Silvano, a potential client, a discount on a policy benefit. She recommends adding a term rider free of charge if he buys a permanent life insurance policy. This is prohibited. Nadia should not try to induce a client into buying insurance by offering riders free of charge. 4.2.3.6 Fronting. Fronting is allowing another person to solicit business and submit it to an insurer under another agent's name, who has not seen or does not know the client at all. The Financial Services Commission of Ontario, FSCO, defines fronting as situations in which an agent holds a license but chooses to have another agent who did not actually complete the transaction sign as the agent of record, or where an unlicensed person arranges the business and has a licensed person sign on their behalf. 333. Last year, following separate advisory board hearings, 5 agents had their licenses revoked as a result of one agent writing insurance policies through the use of other agents fronting on his behalf. More recently, an agent was charged with and pleaded guilty to paying commissions to an unlicensed person. The agent did the business transaction in her name, persons she had not met, and split the commissions with an unlicensed person who had actually completed the transaction. It is unwise and inappropriate for an agent to front business generated by someone else. Agents should not allow themselves to be used by someone else. Not only is fronting improper from a consumer standpoint, but if something goes wrong, it is the agent who will be held accountable. Agents who have participated in such arrangements in the past have not only lost their licenses, but have also frequently been left with substantial chargebacks. Example: Donald, the manager of the local office of an insurance company, recruits Abner to become a life insurance agent. Abner has not yet successfully completed the licensing examinations, so he is not licensed. However, he has approached a relative to buy a term policy, and has brought the completed application and check for the first premium to Donald. Donald signs as agent of record and splits the commission with Abner. Donald should never have employed Abner without the approved license nor signed him as agent of record, and Abner should not have approached potential clients until he had obtained his license. Donald risks having his license revoked, and Abner risks never being able to obtain his. 4.2.3.7 Unnecessary delay in delivering policies. The life insurance agent must not hold or retain documents intended for delivery to the client. According to the Insurance Council of British Columbia's Code of Conduct, an agent must deliver insurance policies or evidence of insurance coverage within a reasonable time, in order to be seen to protect clients' interests. 334. Kenneth received a policy for delivery to a client the afternoon before he went on vacation. He decided to delay the delivery until after his return several weeks later. He arrived at his client's home to learn the client had died a week earlier. The estate's executors took legal action against Kenneth as this unnecessary delay incurred very serious consequences. 4.2.3.8 Misrepresentation. A number of regulatory documents stipulate that it is a violation for any life insurance agent to make, issue, or circulate any illustration or sales material, or to make any statement that is false, misleading, or deceptive. This is described as an unfair or deceptive act or practice in the Insurance Act of Ontario when any illustration, circular, memorandum, or statement that misrepresents, or by omission is so incomplete that it misrepresents, terms, benefits, or advantages of any policy or contract of insurance issued or to be issued. Any false or misleading statement as to the terms, benefits, or advantages of any contract or policy of insurance issued or to be issued. 335. Example: John, a life insurance agent, sends a newsletter to his clients stating that ABC Life Company insurance products have a 100% guarantee on all life payments, no questions asked. The insurer was never made aware of this newsletter or its content. Years later, a claim made by the beneficiary of a life policy issued by ABC Life Company is refused. The policy had been issued through the agency of John. The beneficiary sues John for the full amount of the death benefit on the grounds of misrepresentation, using the newsletter as evidence. For .2.3.9 misappropriating client funds, commingling of funds. Taking money or other property received from the client for a specific purpose and fraudulently misapplying it to another purpose is considered a deceptive practice and is illegal. The Alberta Insurance Council Code of Conduct states the following. Where an agent collects or receives funds on behalf of an insurer, they must not encumber the funds without the prior consent of the insurer. Not use or apply the funds for purposes other than as described in the agreement with the insurer or the client. Pay to the insurer all funds collected or receive. 336. Example. Joe, a life insurance agent, asks two of his clients to make their checks payable to him for transmission to the insurer concerned. The first check is for investing into a tax-free savings account, TFSA, and the second check is for repaying a loan against a whole life policy. A few days later, Joe informs his clients that the funds have been sent to the insurer when, in fact, he deposited the money into his own bank account. Joe was subsequently arrested by police and convicted of theft over $5,000 under the Criminal Code. 337 Evidence of misappropriation of client funds is sufficient to support a finding that Joe should be prevented from being licensed as a life agent. A number of insurance companies have a no-cash policy in regard to premium payments with an application. They require a check drawn on the client's account. Cash makes record-keeping more complicated. Moreover, cash opens the agent up to claims of wrongdoing if the insured asserts he paid the agent more than he actually did. An agent should never deposit money in his own account, even if the intention is to issue a check from that account to an insurer. Insurers generally include in their contracts strict rules regarding third-party payments for premiums. For .2.3.10 Making a false document, forgery. Forgery is a criminal offense and involves the agent making a false document and knowingly doing so. 338. Example. Harry, a life insurance agent, is aware of the terminal illness of one of his wealthy clients, who has never named a beneficiary, and who has Northwest family or close relatives. In the month prior to the death of his client, Harry decides to file an application to name as the beneficiary of the policy a mutual friend of his, and a client with whom Harry has conspired. Harry forges the signature of his client on the application to give it the appearance of validity. In doing so, Harry commits forgery. An agent is required to collect sufficient information to determine client identity and ensure all transactions are lawful. Furthermore, false witnessing of signatures and false declarations violate the professional standards set out in the various codes of conduct. Example. Having never met with his client, Alessio signed as a witness to client signatures on a life insurance application and declared that he completed the application in person with his client. Alessio has in effect submitted a false document. There are extenuating circumstances that may warrant that the documents are couriered to the clients, but this requires that only the intended recipient signs for the package and show photo ID at the time. In this case, a postage-paid return envelope is provided for the client to return the documents to the agent/insurer, and the client is advised to have someone witness the signatures. The witness should not be someone who is connected to the contract or could benefit from the contract. For .2.3.11 Holding out improperly. Holding out can be described as a way a life insurance agent carries out his business. Any agent who does not comply with either of the requirements mentioned below is said to be holding out improperly. According to the Canadian Association of Independent Life Brokerage Agencies, CIWM, a life insurance agent who holds out properly must ensure his license is posted in a publicly visible place. Hold out under the name on the license unless provincial regulation allows otherwise. Not mislead as to qualifications or the nature of business being conducted. Avoid terms that indicate meaningful specialized training and competency unless the agent has actually achieved the claimed level of training and/or competency. Not claim to have associates unless there is at least one licensed individual with equal or better qualifications. Black small square not hold out as a financial planner, unless holding a planning designation recognized by the Financial Planning Standards Council. Point 339. Example. Cynthia had new business cards printed with a designation she had not earned. She therefore misled her clients and potential clients into believing she had the qualifications reflected by the designation. Cynthia had therefore been holding out improperly, which is a deceptive practice. For .2.3.12 misusing company provided illustrations. Life agents should present information about a product accurately, honestly, completely, and in clear language. Agents must not change illustrations produced for a client by the insurer. Similarly, they should not manipulate software beyond its defined parameters to create an unreasonable expectation. Gary received an illustration for a potential client. The results were not what Gary expected, so he modified the illustration, removing the surrender charges the company illustration contained to make it look more appealing. This is a prohibited practice and misinforms the client. For .2.3.13 defamation. It is unethical for a life insurance agent to be maliciously critical or derogatory about any colleague, agency, or insurer. As the Insurance Council of Alberta sets out in its Code of Conduct, it is not proper practice to discredit insurance companies. Point 341. Example. George is upset that another agent, James, acquired one of his potential clients. George sends an email to all his clients making malicious and derogatory comments about James, James's office manager, and the company James represents. This behavior goes against the ethical standards of a life insurance agent. For .2. Making proper disclosure. Disclosure of information is an expected regulatory outcome. Disclosure is entrenched in the approach to risk-based market conduct regulation, and to reinforce fair treatment of clients. Point 342. All of the information submitted on a life insurance application can have a direct bearing on whether the policy is issued or rejected. Navila, an agent, does not disclose to the insurer that Leslie, the applicant, has a pre-existing health condition. Navila reasons that if this information were disclosed, the insurer would apply a rating and Leslie would decline to proceed with the application and pay the additional premium, leaving her uninsured. Believing that it would be in Leslie's best interest to have the insurance, Navila completes the application without noting Leslie's pre-existing health condition. Navila explains to Leslie that omitting this detail will keep the premium down, and Leslie gratefully signs the application. Upon Leslie's death, her beneficiaries were expecting the funds needed to pay off the balance owed on Leslie's mortgage. Instead, as a result of the misrepresentation of Leslie's health on her application, the insurer returned the premiums paid, a much lower amount, leaving her beneficiaries with no choice but to sell the house to pay off the mortgage. Navila should never have omitted this pre-existing health condition, as it was dishonest and did not serve the client's best interests or that of her beneficiaries. For .2.1 Product disclosure. Agents should also provide complete information about the product and how it meets the client's needs, as well as the life agent's business relationships with the insurer. At a minimum, the following key items should be disclosed in writing. Black small square provinces and territories in which the agent is licensed to sell. Black small square the insurers that the agent represents. Black small square the nature of the relationship with the insurers represented. Black small square how the agent is compensated, method of remuneration. Black small square if the agent may be eligible for additional compensation, cash or non-monetary, such as travel incentives, based on other factors, for example, volume of business placed in specific period. Black small square any conflicts of interest. Black small square the fact that the client has the right to ask for more information. 343. Regardless of what disclosure is made and how, life insurance agents should have documentation in their client files that provides evidence that the appropriate disclosure has been made. For .2. Disclosure about replacement. To fully understand policy replacement disclosure, a life insurance agent should have a basic understanding of 344. Black small square how policies differ. Black small square why it might be appropriate to recommend replacement. Black small square the risks inherent in replacement even where it may be appropriate. Black small square existing insurance that may have cash values. Black small square negative tax consequences. When replacement of a life insurance policy is involved, the agent must comply with all pertinent disclosure requirements that are designed to protect the interests of the client. Canadian regulatory authorities have adopted a harmonized disclosure form regarding policy replacements called the Life Insurance Replacement Declaration, LIRD, .345. This document outlines a number of essential elements that the client must be aware of prior to the replacement of a life insurance policy or rider. It helps ensure that the client receives full disclosure of all relevant details required to make an informed decision. A written comparative explanation of the advantages and disadvantages of replacing the life insurance policy must be completed with the LIRD, and copies of the documents provided to the client. Life insurance agents may want to use questions in the declaration to guide their written explanations. Once the agent has completed the declaration, he is expected to go over the written explanation with the client. Example: Roberto, a life insurance agent, is contacted by a policyholder who is interested in increasing her life insurance coverage. She has a $100,000 permanent life insurance policy and wants to use the $40,000 cash value to buy a $250,000 permanent life insurance policy, and is leaving for vacation in 2 days and wants Roberto to expedite this replacement as quickly as possible. Roberto knows that replacing an existing life insurance policy with a new one is often not in the policyholder's best interest. However, and is in a hurry, and Roberto feels that there is not enough time to explain to her all the pros and cons of a replacement. He does not want to risk losing the sale by making an impatient. Roberto acted appropriately when he decided to tell, and that regulations require that he discuss the situation with her further and provide her and the insurance company with a summary of this discussion. 4.2.4.3 Commission sharing. Commission sharing is the payment of a fee, or an exchange of something of value, that is based on a percentage of commission earned on a sale of a life insurance product. Before splitting commissions with another life insurance agent, the agent should ensure that the person is appropriately licensed where necessary, in order to receive the split. Moreover, it is an obligation of the agent to disclose to his client that there has been or will be a commission splitting and provide all relevant details of the commission splitting to his client. 346. Example: Fidos is a real estate agent. His client Martha has just purchased a beautiful mansion, and Fidos recommends that she visit his licensed life insurance agent, Fred, who can help her obtain life insurance to cover her mortgage in the unfortunate event she should pass away. Unbeknownst to Martha, Fidos always recommends Fred because they have a private agreement whereby Fidos receives 50% of the commission owed to Fred from the sale of the life insurance product. Martha purchases the life insurance without full disclosure of the facts. 4.2.4. For referrals and referral fees. Referral arrangements consist of a fee paid for each lead or prospect, regardless of whether a sale eventually occurs. These payments cannot be contingent upon a sale, and cannot be a percentage of the commission earned unless the payment is being made to another licensed individual. The agent should disclose details of referral arrangements to clients. The document setting out licensee responsibilities, issued by the Insurance Council of British Columbia, confirms this by stating: before paying a referral fee, certain conditions must be met. Black small square licenses must be satisfied that the person to whom they are paying the referral fee did not engage in any insurance activities with the client. Black small square once satisfied the third party did not act as an insurance agent, a written disclosure must be provided to the client stating that the person is being compensated for the referral. 347. Any payment of a referral fee when the above conditions are not met will be considered a deceptive practice and may lead to penalties. This may vary from one jurisdiction to another. The agent should take the time to verify with the relevant regulator before entering into a referral fees agreement. Example: Jonathan has an arrangement with several real estate agents who will refer home buyers to him for life insurance. He pays a flat fee per name referred and the payment is disclosed to the potential client. If Jonathan had not disclosed this to his clients, he would be acting in an unethical way. In Ontario, the Insurance Act does not prohibit referral fees. What it does prohibit is a person or corporation acting as an agent without having a license, or an insurer, agent or broker paying a commission, or anything of value, to a person who is not licensed and is engaging in activities that would require licensing. Yes, for 03 of the Insurance Act. As long as the person who provides the referral is not engaging in acts that would require an insurance agent's or insurance broker's license, that person and the agent may enter into a financial arrangement for referrals, not sharing of commission. The Insurance Act does not specifically address or set a value for such referrals. It should be nominal in nature. 348. For 2.5 Acting in compliance with regulations and codes of conducts. Agents have a responsibility to act in compliance with the regulations and requirements applicable to them in the various regulatory documents they will read and sign. 3 of the main responsibilities are discussed in the following order. Small square maintain the required liability insurance, errors and omissions, E&O, coverage, or professional liability insurance. Small square document the file. Small square deliver the contract. For 2.5.1 maintaining the required liability insurance, errors and omissions, E&O coverage. Agents are required to have errors and omissions, E&O coverage. It provides indemnity for negligence, error, or omission, professional liability insurance, and protects life insurance agents from financial losses they may suffer. As FSCO points out in their requirements, all life insurance agents must have errors and omissions, E&O, insurance as specified in Section 17 of Regulation 633, as amended by Regulation 760-94 under the Insurance Act. The E&O insurance is required for selling activities under a life insurance agent's license, and not for selling activities under other licenses or registrations. 349. Example 1. Lowena sues her life insurance agent, Anthony, to recover a financial loss stemming from him having provided incorrect advice. This is an error on Anthony's part, and he can claim on his E&O coverage. Example 2. Kensa made a complaint about her life insurance agent, Paul, because he had not informed her of an important issue pertaining to her annuity contract. This was an omission on Paul's part, and he will use his E&O coverage to provide indemnity for any financial loss Kensa may incur. This coverage applies to negligence, errors and omissions, but not to intentional acts, misappropriations, fraud or criminal activities such as forgery. 3. The agent should maintain uninterrupted E&O coverage in accordance with the requirements of the province or territory in which he sells life insurance or provides service to clients, and if required, arrange and pay for extended errors and omissions coverage if leaving the business, retiring or selling the practice, runoff insurance. Example: Elizabeth, a life insurance agent, intends to retire at the end of the year. She intends to maintain her E&O insurance coverage as long as possible. She also intends to negotiate with the person who buys her book of business to accept liability for any claims after she sells it. For 2.5.2 documenting the file. In order to mitigate any potential complaints or even lawsuits against an agent, he must keep detailed notes and correspondence of the original transactions, the recommendations made, and the client's acceptance/non-acceptance of those recommendations. By doing so, the agent will have the necessary proof readily available to prove he carried out his business correctly. In the event that the agent made an error, the relevant files will show this, and the agent will need to take the appropriate steps with his E&O insurer. Example: Tuanon, a life insurance agent, is contacted by a lawyer representing a client, Jackie, who claims misrepresentation. They are threatening to file a lawsuit against him seeking damages, and to go after the removal of his insurance license. Tuanon will need to have all the files and documents available to help defend his position. Tuanon must also notify his E&O insurer immediately of the situation. For 2.5.3 contract delivery. In delivering a contract to the insured, the agent has important duties to perform, which must be carried out accurately and in good faith. An agent should not deliver the policy to the client without verifying and ascertaining any potential change in his health status. An agent must be certain that between the time of signing the contract and delivering it, no change in the health status of the client has occurred. When the insurance policy is delivered, usually within 30 days, the agent must check that the insured is still in good health. If the agent notices that there have been significant changes in the client's insurability since the application was signed, he must not give him the policy, and he must have the application updated. Jeff, a life insurance agent, meets with his client Annabelle to have the finalized contract signed. As soon as Annabelle walks into his office, he asks if there has been any change in her health since he asked her the initial questions on her health status. Annabelle says no, and that the nurse had visited to carry out the routine check. Jeff is satisfied that all is in order and delivers the contract. If Annabelle had said that she had been hiding a pre-existing health condition, or recently been diagnosed with an illness, then Jeff would have had to submit another application with the up-to-date information. For point 2.6, handling complaints in a timely and fair manner. Life insurance agents are required to handle complaints in a timely and fair manner. Agents are obliged to deal with complaints in good faith. Point 351. For .2.6.1 definition of complaint. A complaint is defined as an expression of dissatisfaction about the service provided by an agent. It may involve a claim for a financial loss. For .2.6.2 ethical complaints. Complaints involving unethical behavior or alleging violations of codified ethical standards, such as a code of conduct and ethics, should be taken seriously. For .2.6.3 procedures to follow. The life insurance agent should maintain a complaint log, register, to track complaints, to provide any required reports, and to maintain a state of readiness for regulatory and other audits. The complaint log should maintain information in a consistent fashion. At a minimum, it should summarize the following. Black small square life insurance agent. Black small square instances of complaint, whether written or oral. Black small square recipient of complaint. Black small square individual handling the complaint. Black small square summary of complaint, with details on whether a regulatory authority is involved. Black small square whether the complaint was reported to the insurer and or managing general agent, MGA, and the contract information. Black small square steps towards resolution. Black small square statement of resolution. Black small square date of resolution. For point 2.7 core ethical values, it is important that the life agent keep his business practice and conduct within the principles and the rules of core ethical values, which, as discussed, include black small square acting in good faith, care, competence and integrity, black small square managing conflicts of interest properly, black small square refraining from unfair or deceptive acts or practices, black small square making proper disclosure, black small square acting in compliance of regulation and codes of conducts, black small square handling complaints in a timely and fair manner. It is recognized that all industry players, agents included, benefit from enhanced public trust. This trust can be maintained by developing an ethical culture that will provide a framework that motivates and guides appropriate agent decisions. For point 3, licensing process and regulations, this section describes the licensing process and regulations for carrying a license. For point 3.1, purpose of licensing. Life insurance agents and agencies licensing is an integral part of the legal and regulatory framework. The notion of public order in licensing aims to protect the public against incompetent agents, unfair or deceptive practices, and unethical activities. Licensing is fundamental to the regulation and supervision of life insurance agents to adequately protect clients. Life insurance agents are required by statutory law to hold a life insurance license for each province or territory where they carry out business. Terminology such as authorization, certification, or registration are sometimes used in place of licensing, depending on the province or territory. For the purposes of this chapter, these terms are collectively referred to as licensing. It is the life insurance agent's responsibility to limit his practice to areas in which he has been trained educated, and above all licensed. An agent should only sell what he is licensed to sell, and only in the province or territory in which he is licensed. 4.3.2 Licensing Regime. New applicants for a life insurance license must have completed the Life License Qualification Program, LLQP. There are two types. Black Small Square Full LLQP. Black Small Square LLQP Accident and Sickness, ANS. The full LLQP combines life insurance and accident and sickness insurance training. The LLQP Accident and Sickness, ANS, covers accident and sickness insurance only. An ANS agent would then be prohibited from selling any other type of insurance, unless he obtains the full license to do so. In addition to passing the LLQP, the applicant must submit a fully completed application to the appropriate licensing authority, and the application must be approved before a license is issued. New applicants must complete all forms honestly and accurately. Any false or misleading statements provided by the applicant may result in license revocation and administrative penalties. An applicant may not conduct insurance activities without holding a valid license. The applicant must then obtain employment or an agency contract. The difference between agent certification and agency certification is that the first pertains to an individual, while the second pertains to a corporation. Fully licensed agents are able to sell products which include the following: Black Small Square Individual and Group Life Insurance Policies. Black Small Square Individual and Group Accident and Sickness, including disability insurance policies. Black Small Square Individual and Group Annuities, including guaranteed investment accounts, GIA, segregated funds and immediate annuities. 4.3.3 Selling to and servicing out-of-province clients. For life insurance agents wanting to sell to clients located in another province or territory of Canada, a reliance model of reciprocal licensing has been created whereby regulatory authorities in other provinces rely on the requirements of a life agent's home jurisdiction, with the option to request that an agent meet further requirements specific to the new or host jurisdiction. The model harmonizes application forms, continuing education standards, and errors and omission (ENO) insurance requirements for agents. Provinces and territories are not currently required to introduce any additional licensing requirements. This more streamlined licensing regime makes it easier for life insurance agents to be licensed in multiple provinces. Clients also benefit by being assured that life agents have met common licensing standards across the country. 4.3.4 Revoking of license. The regulatory authorities issue the license and are empowered to suspend or revoke it for any activities they deem inappropriate, unethical, or illegal. Regulatory authorities maintain records of agents who have had substantiated complaints, suspensions, and revocations of licenses. These records are available to clients. An agent who has had a license suspended may find it extremely difficult to obtain the trust of potential clients. An agent who has had a license revoked will find it extremely difficult to obtain a license again. As stipulated in the Insurance Act, Ontario Regulation, the superintendent may suspend or revoke a license on any grounds on which an application for a license may be refused, or if, after due investigation and hearing, it appears to the superintendent that the licensee A. has violated any provision of the license in the licensee's operations as an agent, B. has made a material misstatement or omission in the application for the license, C. has been guilty of a fraudulent act or practice, or D. has demonstrated incompetence or untrustworthiness to transact the insurance agency business for which the license has been granted. 353. 4.3.5 Other products and services for which a license or registration is required, not exhaustive. The selling of the products and services below require an agent to be licensed in Black Small Square Property and Casualty Insurance, Black Small Square Securities, including exchange-traded funds, ETF, or mutual funds, Black Small Square Mortgage Brokering. 4.3.5.1 Property and Casualty Insurance. To sell property and casualty insurance, a life insurance agent is required by law to hold a separate and distinct insurance license. For .3.5.2 securities, including exchange-traded funds, ETF, or mutual funds. To sell securities such as stocks, bonds, options, commodities, ETFs, or mutual funds, a life insurance agent must have a license from the relevant securities regulatory or self-regulatory organization. Each type of security typically has its own license or separate registration. For .3.5.3 mortgage brokering. A life insurance agent wanting to engage in a mortgage brokerage or to act as a mortgage broker must be licensed by the proper authority. Mortgage brokerage licenses are issued by mortgage broker regulators, which vary from province to province. If a life agent is carrying out mortgage referrals, he should ensure compliance with legislation regulating mortgage brokers. Typically, a life agent does not need a mortgage brokerage license to give referrals that provide limited information about a borrower to a potential lender, and vice versa, if the information provided is appropriate. For .3.6 other products and services for which no license is required. Conversely to the products and services above, the following are subject to certain exceptions as described below. For .3.6.1 acting as a deposit broker. Acting as a deposit broker for banks or other deposit-taking institutions in Canada does not require a license. At present, no regulatory authorities oversee the activities of these brokers. For .3.6.2 acting as a financial planner. Although a licensed life insurance agent does not need a license to advise clients on their financial situation, and may even feel competent enough to provide financial advice in areas other than life insurance, it would be misleading for a life agent to refer to themselves as a financial planner. However, licensed life insurance agents must be careful when referring to themselves as such, since each jurisdiction might have different rules regarding the use of that title or similar titles, such as financial advisor. 354. Conclusion. As seen in this module, insurance agents are subject to various ethical and professional practice obligations, which are imposed by applicable legislation, codes of conduct, contracts, etc. Ethics and abiding by the rules of professional practice are fundamental to licensed insurance agents, and essential in achieving the common objective of insurance regulators to promote professional excellence for the ultimate benefit of the public. High ethical standards are critical to maintaining the public's trust in the insurance industry and in the profession of insurance agent. Sanctions for non-compliance with the principles and rules that apply to licensed insurance agents can include important monetary penalties and revocation of the agent's license. The insurance industry is heavily regulated, and insurance agents cannot be expected to know all legal aspects in intricate detail. Nonetheless, it is very important that insurance agents be familiar with legal aspects and be able to guide clients in the insurance process. Agents should never hesitate to refer clients to other professionals, such as lawyers, accountants, and tax specialists, advisors when questions from clients are outside the scope of their insurance practice.